that's where we are with the litigation. And I know that we've spent a lot of money getting to this point. And it's taken 4 years, 5 years to get to this point. But in my opinion, we're on the 1 yard line. And you've paid a lot of money to get to the 1 yard line. We need to push the ball over the goal line. And I don't think we want to be like the Seahawks and take 2 steps back and go for the Hail Mary pass. We know how that turned out. So that's my spiel. And I'm glad to answer any questions that anybody has.
Would you entertain, first of all, I want to thank you for the synopsis. I think it was concise and easy to understand.
Good.
But would you entertain a question kind of outside the lawsuit itself with respect to the establishment of the district? Because what I'm having trouble grasping here is the fact that I think typically enabling legislation of this nature allocates costs to the users of the district and not to the county, even though it's a county district. In this particular case, if we were to settle and pay, as Exhibit A indicates, 1/3 of the cost, right? We would be paying 1/3. Is going to be for the settlement?
No, that's not correct. The settlement, as it's proposed now, as it was negotiated by the sanitary district and, the 3 members of the legislature that were on that panel, the settlement there was the county defendants, which are defined as the County of Montgomery and the Montgomery County Sanitary District Number 1. Those two entities, the county defendants, would pay to the plaintiff $250,000.
Okay.
Village of Nelliston is really a non-player in this.
Okay.
They're there only because their pipes are there, only because the plaintiff has brought them in. They have played only a very nominal role in this whole thing.
All right. And which of the entities actually conveyed the property again?
This Montgomery County Sanitary District in 1989 purported to convey title to Ms. Cruz, but because they had no statutory authority to do it, it's a void, null
Was that a
situation.
misfeasance, a non-feasance, malfeasance, whatever it was?
It was an exercise of power beyond the powers that district board had at the time. They didn't have the power to do it. It was what in the law would call ultra vires,
Okay,
beyond
outside.
the powers, outside the power of their office.
Okay, so in essence though, if the county is going to be paying half of this agreement, we're pretty much rewarding the district for their action. And
Well, let's not think about this for a minute.
Well,
though.
hang on one second, let me
Okay.
finish my point. And we really get no benefit. People who are outside the sewer district get no benefit of the district. Now, there are other sewer districts, and I mean, there are other entities in the county that have to pay sewer taxes, et cetera. Okay, so what I don't understand is why the county is responsible rather than the district itself.
Let me see if I can answer parts of that. I don't know the answers to all of it. I can tell you that when this lawsuit started, we went back through all of the county resolutions that are in Cheryl's office. I don't know if you remember that, Cheryl. My associate and I went down and we spent a whole day going through the resolutions that related to the adoption and creation of the sanitary district so that we would understand exactly what the powers were of the district, what they could do, what they couldn't do, and how they were set up. And in none of that documentation do I recall reading anything with regard to what the apportionment of fees would be or how any of that would happen. I don't know anything about that. Well, let me just say this, that the district was created by the entire county under a county law which allows counties to do that, to create sanitary districts. It's probably no different than the county running a county nursing home or county hospital, where not everybody in the county has a benefit of it. So we live in a society. Society decides that certain things are good, and we're going to work cooperatively and pay cooperatively, even though I'm not getting any particular benefit out of the sewer trade district.
Because everyone would have access to it.
Well, let's use an simpler example. I don't have any children in a 4-point school district. I pay lots of school taxes. Why should I pay school taxes when I have no children in the district. This is the same kind of an
But
argument.
well, no, it's not, and I'll tell you why. Because my question goes to the enabling legislation rather than some philosophy of how we should pay for education. So what I think in that legislation, there is something that alludes to the distribution of costs going directly to the users.
Well, I believe that the services in the district they tax the users for the use of the facilities. So much money is paid for water and sewer rents and stuff like that. So if you're in the district, you pay a district assessment for sewer, okay? That's unrelated to the establishment of the district. That's unrelated to the county's responsibility as oversight committee for the district. And that gets back to the other question, is the county sanitary district gave the land away and they shouldn't have, and it's all on them. But then you have to say, well, if it's an administrative unit of the district and members of the county legislature or the county board of supervisors were on that district, was there some kind of lack of oversight that should have been exercised? Okay.
See, because one of the things we're facing right now is my understanding that the district doesn't even have funds to pay its half.
Well, I can say this, that I had nothing to do with deciding how
Right.
the county defendants would come up with the funds to pay. All I know, I'm a foot soldier, I was told, here's the deal, who's gonna pay, write up the agreement so it reflects the concepts and the agreements that we wanna have. And it said county defendants pay $250,000. How those county defendants apportion it amongst themselves is not really the role of me as an outside counsel who's just involved in the litigation. That's something that is more internal between the county and the district.
Right. So that's one of the reasons why I questioned the settlement was, it said Montgomery County, it didn't even mention.
It says county
that
defendants.
we were looking at.
It says county defendants, yes. The one that I would have preferred you had seen says county defendants are going to pay, and it leaves open the question, you're right, what's the breakdown between the two? Wasn't something I cared
So we're
about.
about to reward somebody's ineptness here.
Well, I don't know if I would put it that way. I mean,
I have no trouble putting it that way.
Okay. I think a better way to look at it is, what is the value, what is the benefit that the county and the district will acquire by virtue of paying $250,000 to settle this lawsuit? Okay, the lawsuit
I would
is
agree with
over,
that.
you're tired of
Yeah,
dealing with it, it's a nuisance to you, it's costing you money every month that I work on this project. I understand that, but should you just settle cases because you're tired of dealing with it? I mean, that's what your job is, to deal with these
No,
problems.
of course, one of my concerns is it's quite common for sewer districts to be cited for violating speedies permits, as an example. And there are fines associated with that. So I'm just wondering how far down the road we're going to be going with these things, that this type of settlement makes me feel uncomfortable, mainly because really, majority of the county are not users of the district. And then that's my problem.
And that happened in 1972. And it's not really part of anything that I've done.
Otherwise, that was the good year. I graduated from college, I got married, and all that was-
Yeah. Other questions?
I have two questions that I just
Sure.
want to clarify. One, and this might not be something you can answer specifically, but who authorized the change in the language for the resolution that was placed on our agenda? Do we have an answer to that, or?
I can answer it.
You want to answer it?
Go ahead.
I made the changes when it was brought to my attention that the resolution contained the language that the stipulation would be attached to it. It was brought to my attention by the clerk of the board, the clerk of the clerk of the legislature, and the chairman of the legislature, and I had a brief conversation in that room two Tuesdays ago tonight, at which time I was asked to change it. And so I did. And I rewrote the last couple of paragraphs of it and submitted it back to the clerk of the legislature.
Thank you. And my other question for
If I may, which is in conformity with our usual practice in that we don't typically attach such documents to the resolutions themselves. I'm not saying it's never done, but generally it is not. It has not generally been the practice of the Board of Supervisors or of the legislature in the period I was here. So when this was brought to my attention, it made sense to make that change.
Thank you. And my second question for clarification is, and I think I know the answer, but in 1989, the deed from the Montgomery County Sanitary Sewer District to Cruz, was that authorized in any way by the county? And if not, who was it authorized to be signed by?
The second question is, it was never authorized by the county, and the sale was never done pursuant to the county law, which has a whole series of events that have to happen for the county to divest itself of title, including public hearings and a variety of other procedural safeguards to protect the county from the very thing that happened. Through lack of attention to detail, something being done that results in the county losing a valuable asset. And that's right, and the judge recognized and says that the procedures for transfer of a county asset was not followed, and therefore this deed is void, okay? So how was it done? The chairman of the district, let me say this, I have looked at all of the meeting minutes from the sanitary district from 1972 forward, okay? In about 1974, there was the bright idea that we ought to sell some of the surplus land that the district had acquired for sanitary purposes so it would get back on the tax rolls. The chairman of the sanitary district at the time was a fellow by the name of Harvey Gramps. Harvey Gramps contacted a local attorney. The local attorney and Mr. Gramps apparently sat down together, did a deed, sold the property on a 10-year payout, lease, and option to buy kind of a situation. And there were all kinds of problems with that over the 10 years, but eventually a deed was issued in 1984, lost by the grantee, and then another deed was done in 1989 because they couldn't find the original deed. Same parties involved. So it was done strictly at the district level by the sole actions of the county sanitary district chairman. There was apparently a vote, but the record is not complete of who voted for what. All I know is who abstained.
So
I don't even know if there was a quorum in the room at the time the resolution was passed to authorize Mr. Gramps to sign the deed.
So it was authorized by the sanitary sewer district, which they did not have the power to do.
That is correct.
Okay, thank you.
Terry? You stated that how the payment is split between the entities isn't really a factor with the lawsuit, correct?
No.
Okay.
Here, let me just say this. The number that was arrived at is how much are we willing to pay this plaintiff to have this lawsuit go away? That number was established at $250,000, and the district board, which is made up of some members of this board,
Right.
said we're going to do, the county defendants will pay. And there was never a discussion about how that was going to be split up between the county defendants, to my knowledge.
So if this board decided, if we took a vote and decided that the sanitary district pays the whole $250, that would be,
Wouldn't change it if, as long, let's assume they have $250,000.
Right.
It wouldn't change the settlement agreement at all.
okay.
Did the district endorse the settlement in some way? Did they vote to?
I can tell you that similar resolution was sent to the sanitary district as the one I sent to this board. Similar resolution was sent to the village of Nelliston. The village of Nelliston and the sanitary district also modified their resolutions. And the village board passed a resolution similar to the one that was presented to you last week. And they adopted it 3-0 to approve the settlement. Of course, they have only, like I said, a sideline interest, and they're not putting any money on the table. But they have endorsed the settlement, okay? This settlement, by the way, requires, if the county, when the settlement goes through, it requires the sanitary district to enter into an agreement with the village of Nelliston to give the village of Nelliston an easement for sewer lines that are already in the property, in the ground, but no one ever thought to get an easement. And there are other things that are wrong there as well, but I won't get into that.
Yeah, please.
As far as the sanitary district, last week, on Saturday of this past week, the 21st, sanitary district took the exact same resolution that I presented, passed that resolution with the exhibit attached, okay, and by a vote of 4-2 and 1 absent, approved the settlement.
And 3 of those members are here. Did we have people here that voted on that?
Myself, Martin, Roy was absent.
Was there meant to be that kind of overlap, or I don't want to call it oversight, I don't know, it's too late for that.
I mean, on the board, you mean?
Yeah.
Yeah, that was intended, it was intended that the sanitary district board be made up of members of the county legislature, members of the municipalities in which the sanitary district has facilities. So it's the village of Palatine, the village of Nelliston, the village of Fort Plain,
Town of Palatine.
town of Palatine, town of Canajoharie, no, not Canajoharie.
Yeah.
Oh yeah, Canajoharie, yeah. So everybody who was a party to, participates in the sanitary district, every municipality had a representative, plus there were representatives from the county. Always, and that's how it was set up since 1972.
With 1 member at large.
1 member at large.
Well, that didn't.
And Barb is next in line, and then Tom.
Thank you. So if the sewer district, if we did go with the suggestion that was just brought up, the sewer district could proportionate it, could proportional an allotment out to each municipality if they wanted to get some money to the people that did utilize the sewer district. But I do have a couple questions. In the 6 years that you've been on this, and around 266,000 around. The liens, the mechanic liens, you haven't resolved that or found, I understand that there was a put out. Now, I am fortunate enough to have been on the Board of Supervisors, and I don't remember you coming forward with a settlement. Now, that being said, I am concerned about a $290.
96,000.
96, wonderful.
Can I get to the question about the mechanics liens?
Yes,
Okay,
please.
so Patterson hired several people to do work on this parcel of land, 101.87 acres of land,
Heard it
okay?
many times.
Okay, they did work, they cleaned up the site. Patterson never paid them a nickel. None of the contractors were ever paid a nickel. So, for years, they have been apparently being told, as soon as I get my money from the county, I'll pay you, okay? That's worn thin on the contractors. And so now, in December 15th of 2014, and January 5th, 2015, 2 of those contractors filed mechanics liens for the first time. And they filed those mechanics liens not against the county or any of the assets of the county. They filed it against Mrs. Patterson because those are the party who they had a contract with, and it affects the real property because on a private improvement mechanics lien, the lien is against the land. Part of our settlement with Ms. Patterson is that she has to convey to us a quitclaim deed to this property, free and clear of all liens and encumbrances. She is responsible for cleaning the title to this property and getting those contractors' liens discharged.
So that eliminates the liens legally for us.
No,
Didn't you just say,
no.
All right.
If you have a claim against me, you might have a claim against me because I'm a mechanic who, you've done work for me, I'm a landowner. You've done work for me and you have a claim under the mechanics lien law, which is let's see what I can say. a process whereby you can, by simply filing the lien against the property, create some kind of collateral against the owner that says, if you don't pay me, I can force the sale of your land where I put improvements in the ground to get paid. But if I don't want to file a mechanics lien, I don't have to. I can just say, I had a contract with you, and I'm gonna come over here, and now you're gonna sue me on a contract theory. This is where we are. A mechanics lien is only one of several different causes of action that the contractors have. And so, if the mechanics liens gets discharged, that's one of the arrows in their quiver that they can't use against us. But they still have, we did work on land that's owned by the county, we've improved it, we've added value to it, you owe us money for the improvements that we've made, because otherwise you were unjustly enriched.
If it's owned by the sewer district, though, they would go after the sewer district. And the other comment I had is, again, I don't believe this is the first settlement that's ever come before this body.
I have been here
And the other-
3 times.
I wasn't done.
I'm sorry.
Thank you. But what I've been able to assess is this is a Hatfield and McCoy's. This is a personal thing, and we need to represent the taxpayers. So I appreciate the work you've done. But I don't think I do.
Could I respond one thing? I have been here. I have put on, when it was the County Board of Supervisors, if you might recall, I had a slide
I do
presentation.
have one more question.
And I
though.
did pass out all kinds of documentation about the proposed settlements, where they stood and what they meant. So it is not correct to say that this board, when it was the County Board of Supervisors, had not seen settlement proposals or had not had me here to explain the status of the case. This is the first time I've been here since the new legislature has been enacted.
You presented a settlement to the Board of Supervisors?
I did.
There was a settlement offer.
There was a settlement offer, and I came here and put on a PowerPoint presentation explaining the settlement.
I've been on the sewer district since 1997, so I don't go back quite to the time that the sale took place. So you can't blame me for that. Or Jim Post, my colleague from the village of Palatine, I think you were there before me, right, Jim? But we weren't involved with the sale, so. I mean, I could go on all night about you know, what I feel and what we need to do, and part of the reason you have a settlement before you tonight is because I have obviously agreed and want this thing to get over. But I really just want to touch on a couple of things. Duke had asked several questions about the entity itself and how it works, and whether or not, somebody had said about whether or not there were fund balance. We've typically always carried about a 300, someplace in roughly $300,000, $310,000 fund balance. With the storm damage that took place, we had to expend some of that money, which left us now with $78,000 in fund balance. However, Sean has indicated that the $200,000 FEMA is paying us, the county's going to give us that money. Treasurer's office is going to pay the sewer district that money because they have outstanding problems with money that we owe to FEMA, so they're not releasing the money. We're going to get the money, which is going to bring us back up around the 300,000 range when Sean does that. And I don't want to speak for the executive, but I think I'm pretty close to what I'm saying. We're an enterprise fund. We're supposed to take care of ourselves at the sewer district. The monies that we charge, the $240 each year that we charge each user for each facility they have, pays and is supposed to pay. Much like the nursing home, when we own that, was supposed to pay for itself. But remember, and Doug will help me on this if I'm wrong, I'm sure, when the sewer district was formed back 30 years ago, they could only do it under the auspices of the county because they were the ones who had the bonding power. They were the ones who had the ability to borrow the money, not an entity that didn't exist. Therefore, the creation of the sewer district in order to put that facility in place. It is a county facility, whether we like it or agree with it or not. And if it went belly up tomorrow, as the county executive, the money that the county taxpayers have is paying the bill. That's the short of it is, we're responsible for that. So whether we had the money in the fund balance to pay the 100, our share of the 125 or whatever, to me anyway, I'm not saying I agree with it, it's just the way that it is. And Doug, again, or Ken, correct me if I'm wrong, we own it. It's ours, whether we like what happened 35 years ago or not, it's ours. Two points. Our attorney has told us tonight over and over that we've, even in 2009 when he wanted to file the summary judgment, which means we never sold the land. We still own the land after all these years. I guess the point I want to make to you is, if we win on that, if the judge says you're right, that board was wrong, you never sold the land. You own it, you own it all. The environmental part of what Ken was talking about doesn't go away for us because we never sold it. So whatever we allowed, whatever junk we allowed on there, or whatever DEC has remedied or not remedied, we are responsible for that if we win that lawsuit regardless. That's our baby.
Tom, what are your feelings on the apportionment of the settlement?
When the Board of Supervisors entered in, we got involved with the lawsuit, it was agreed by the Board of Supervisors in the sewer district, and Doug, you correct me if I'm wrong, that it would be a 50-50 split. That's been the mindset of the Board of Supervisors in the sewer district from day one.
And have all the bills been paid that way?
And all the bills have been paid, well, I don't know if they've all been paid yet, there may be some outstanding bills, but every bill that's been paid
But to date?
has been a 50-50 split. In regards to, I'm gonna take the same position in regards to what Ken talked about with the potential of others suing us. If we end up with a property because the judge said we never sold it, I don't think those contractors, they still have the potential to come. I don't think it holds any merit. They didn't enter into an agreement with me, with the sewer district or anybody else, but that doesn't mean they can't sue us. Ken's right. But if we take ownership of the property because the judge says we never sold it, that doesn't go away. I would assume they're still gonna go after their money from the people they entered into an agreement with. But if they decided to take it further and come after us, they're still going to, because we own the property. The judge just told us it was ours, if we win on summary judgment. So for me, those two issues are, and again, it's only my opinion. You may all disagree, and Ken also, but we're still there. The potential's still there for someone out there, and to my knowledge, there's only two, but who knows, there could be 20. The point is, did they do work for us at the county or the sewer district, or did they do it for them? Do they have a right to a claim that they did this work? Probably, geez, I wish them all the luck in the world. Go get the money they owe you, just like when somebody owes me money, I want it.
Let me just say two things about that. In our settlement that we tried to get with these people, we said, we're not asking you to clean up the entire site for all the environmental error mistakes that might have been done on this property. What we're saying is that once you got the consent order and you undertook to do work, if you didn't do it right and you created a violation of the environmental conservation law, we want you to contribute toward the cost of cleaning up those violations. Not everything. Plaintiff said no, they wouldn't do that. With regard to the contractor's claims, Tom is right that there was never any contract between the sanitary district or the county and these workers. But these workers did work on land owned by the county and claimed to have improved it. And therefore, under the theory of unjust enrichment, which is what's called in the law a quasi-contract, even though we never had a written agreement with them, because we sat there and watched them do it and never told them to stop, they are entitled to put in a claim. Can we defend against that claim? Yes. And what did we ask for in the settlement? We asked for in the settlement, if we have to defend against the claim, we want you to help pay for the cost and indemnify it. Plaintiff said no. So the settlement we have now, we're still going to be stuck with 100% of the environmental. We're going to be stuck with 100% of the defense of these potential claims that are out there. Whereas under other agreements we tried to get with the plaintiff, we tried to shed some of that responsibility and cost on them, and they rejected it. All they want is their $250 and walk away.
So, back on what I was saying, I agree with what Ken just said, but if the judge decides that we never sold the property, those same burdens are ours. whether they exist, whether. they-
100% of yours as opposed to apportioning, that's all I'm saying.
Right. And, you know, that's the judgment that, you know, this board's gotta decide. I do, think that I can, I'm supporting it. Just letting you know that I'm supporting this because it needs to